All right. Good morning and good afternoon, everyone. Good morning to those of you on the West Coast, and good afternoon to all the rest of you to the east of us. I want to thank everybody. Introduce myself. My name is Roger White. I'm the Manager of National Sales over here at TalentWise, and I'm going to be your host and mediator today. I'd like to thank all of you for joining us for today's webinar, Marijuana at Work, Legal Marijuana and Employee Drug Testing, which is presented to you by us here at TalentWise in partnership with Encompass Compliance Corporation and compliments of our friends over at the Society for Human Resources Management, which most of you know as SHRM. So before we get started, I want to go ahead and go over a few housekeeping items. For those of you that have been in webinars with us before, you're privy to this, but for those of you new to us today, a couple things. So first off, all attendees of today's presentation will receive a copy of the presentation as well as a link to the recording. So if you're unable to see everything today or you want to share that with coworkers, we will be following up with an email after our time together today with that. Along in this email, you will also find that you are qualified for one HCRI credit, and in that email we will also provide you details on how you can take advantage of this, and we'll be sending that out and talking a little bit about that at the end of our time together today. And then very important, if you have any questions along the way, for those of you privy to the system that we're using today, you'll see on the left-hand side there's a chat window. And I'd implore you to go ahead and use that chat window to ask any questions of Bill or Nick today or myself, and we'll be sure to address those at the end. We have some time carved out at the end for a Q&A session. So if at any time during today's presentation you have any questions, please put them in there. If at any point in time you want a personalized demo, whether that be a demonstration of putting together a comprehensive occupational health screening program or anything else that TalentWise does, simply type in "hit me up" in that chat window, and we'll be sure to have a representative reach out to you very quickly. You're going to be reached out to anyway, but this way we can kind of prioritize you and make sure that we have somebody reach out to you very quickly. So. Perfect. So without further ado, let's go ahead and get started today. So again, to introduce myself, again, my name is Roger White. I'm the Manager of National Sales here at TalentWise, and joining us today, very thankful for this, graciously joining us is William Judge, the Chief Research Officer, as well as Nick Hartman, the VP of Channel Partners and Alliances over at Encompass Compliance Corporation. Very excited to have them on with us today and showing us a lot of new information about marijuana today. So. Before we get started, I want to talk to you a little bit about TalentWise. By way of introduction, TalentWise is a technology company that has built a cloud-based platform that streamlines the entire hiring process from offer letter through your new employees day one and everything in between, including background screening, drug testing, which we're going to talk a lot about today, as well as new hire onboarding. Our goal here at TalentWise is to provide your company the means to increase operational efficiency, maintain 100% compliance in all respects, to mitigate risk for your organization, as well as provide the most robust candidate and HR experience that's available out there on the market today. And finally, for those of you privy to social media, don't forget to follow us on Twitter at TalentWise, as you can see on your screen here, and use the hashtag #JointWebinar to tweet during the webinar. That pun there was intended as a fun play on the topic of our discussion today. So we'd love to hear from you. Please go ahead and use that hashtag during today's webinar, and we'll go ahead and follow that on Twitter. So thanks again, everybody, for joining us. We'll go ahead and get started here. So without further ado, I'm going to go ahead and hand off the reins to Nick Hartman. I've actually had the chance to work with Nick for over 5 years myself, and I can confidently say that what you're about to see from him and Bill will answer a lot of your questions around occupational health screening to ensure you've built a comprehensive occupational health screening program at your organization. So again, if you have any questions, please use the chat window. Otherwise, Nick, thank you for joining us, sir. The floor is all yours, my friend.
Appreciate it very much, Roger, and thanks to TalentWise for having us. And a big thank you to everyone joining us today. Encompass Compliance Corp is an automated risk mitigation and compliance tool designed to develop and keep employers current with state-specific drug and alcohol testing policies and procedures in accordance with state and federal laws, as well as court and industrial commission decisions. Please feel free to join us on Twitter as well at DrugCompliance. And before we get started today, I need to advise everything being discussed today should not be taken as legal advice or opinion. This truly is intended for general information purposes only. We ask that you please consult an attorney concerning your own specific situation and for any legal advice. Please take care during the discussion to hear what we are saying, to take it all in, and to not blindly interpret these legal changes. For our presentation agenda, we will cover a few important facts about marijuana and its current use, along with the ever-evolving details surrounding legal medicinal and the legal personal use of marijuana. We'll discuss how federal and state laws conflict, as well as noteworthy employment-related court decisions. We'll do a quick time check and briefly talk about workers' compensation, and then wrap with key suggestions and takeaways for everybody joining us today. All right. We felt it was important to start our discussion with the fact that marijuana is still a Schedule I illegal substance in the United States. This is important in several different aspects, but most notable, as it stands today, federal law will trump state law in most all cases. As a result of that fact, for medicinal marijuana, where it's allowable by state law, which we're going to cover next, medical doctors and even other approved medical care professionals cannot legally prescribe marijuana to a patient. With little exception, they are limited to the ability to simply recommend the use of marijuana. This can be as simple as a verbal doctor-patient conversation or be provided as a documented form of recommendation. Probably not a news flash to any of you, but marijuana is the most popular, or is a very popular drug, I should say. As shown in a study conducted in 2013 by the Substance Abuse and Mental Health Services Administration, or SAMHSA, shows that marijuana was the most commonly used illicit drug with nearly 20 million users, making it the most popular drug of abuse in the U.S., only second to alcohol. And in the same study, more than 80% of all illicit drug users combined consume marijuana. Close to 2/3 of those users indicated that they had used only marijuana over the last 30 days. And compared to studies from 2007, while most other drugs of abuse have shown steady use or a decrease in overall use, the current use of marijuana has increased by more than 5 million people, about a 25% increase overall. Also interesting is that those reporting the daily use of marijuana, which would be using marijuana 20 or more days out of the month, has increased by 3 million people in the U.S. This shows that the trend of marijuana use is growing. And let it be known that marijuana has no age limit. Current use is prevalent for nearly all age groups and generations. Talking a little bit more about the drug, for those that are not aware, there are literally hundreds of street names for marijuana, a few common ones I listed here for you. Marijuana is known to be a mind-altering drug, with its active ingredient being delta-9 tetrahydrocannabinol, or THC. And as I mentioned earlier, the most popular drug here in the U.S., second to alcohol. The most common methods to screen for marijuana use in the workplace is via urine, also via hair follicle and oral fluid. Blood is also an option, but not as popular. Urine testing being the most widely accepted and used method. The detection time period for marijuana will vary for each screening method you choose. Screening via oral fluid, which is gaining in popularity as of recent, will typically give a detection time window of approximately 1 to 12 hours after use, so showing recent use. Screening via urine, again the most common method, will show use from the last 2 to 3 days, but possibly up to the last several weeks for those that use on a frequent basis. And hair follicle, which provides a window of 2 days up to the past 90 days of use. It's important to note there are many variables impacting detection time periods due to the nature of marijuana being a fat-soluble drug. It stores in your body far different than most other drugs of abuse. What's really important here is to utilize the method of screening that's applicable to the situation. Requiring a hair test, for example, to determine if someone has used drugs in the last few hours or days will likely not give you the answers you're looking for compared to that of an oral fluid or a urine-based test that will show more recent usage. Now I'd like to introduce everyone to my colleague, William Judge, again, Chief Research Officer here at Encompass Compliance Corp. Bill has graciously agreed to join us today to provide his many years of expertise on the topic and will give us an as-it-stands today rundown regarding the legal medicinal and legal personal use of marijuana. Bill?
Thank you, Nick. Appreciate it. And thank you to all of you folks for showing up and listening. Hopefully we can present you with some information that will answer your questions, or at least, if not, raise a few more. Medical marijuana was first introduced into this country in 1996 in the state of California. And it has grown to include 24 states now and Washington, D.C., Louisiana being the most recent state to authorize the use of medical marijuana. Louisiana is included on our list, even though at the moment it does not have all of its details in place. The legislation in Louisiana that was signed by Governor Jindal simply authorizes various state organizations and medical groups to come up with plans, the means by which medical marijuana might be established in the state. So at the moment in Louisiana, and this is why some people don't even include Louisiana as a medical marijuana state, but it has authorized those organizations to come up with the means for which it would be accessible to people. These 24 states, and you can see the map there, if you're operating, if you have workplace operations in any of those 24 states, you need to really pay attention to what's going on in your states. And we're going to talk about how different some of these states' rules really are. And you really need to, for your program, pay attention to the differences in these states. Personal use, legal use of marijuana has been authorized in 4 different states. As you can see here, Colorado, Oregon, Washington, Alaska. So in those states, if you're an adult over 21, you can legally purchase marijuana for your own use. There are limitations. Most of those state statutes, by the way, have limitations on use related to the workplace. So once again, you're going to want to pay close attention to what those states' rules are as they relate to your operations of a workplace drug testing program. As was mentioned, the conflict between federal and state law, Nick mentioned that the possession of marijuana remains a crime under federal law. Marijuana remains a Schedule I drug, which essentially means that it has no medical uses and is a highly addictive substance.
Yep, you're absolutely right, Bill.
Go ahead.
I was going to say you're absolutely right. There's even a bit of conflict within the federal government's messaging. An example we have up here in October of 2009, the Department of Justice issued guidelines for federal prosecutors stating that it should not be a priority to use federal resources to prosecute patients for or the caregivers who are in compliance with state medicinal marijuana laws, so that the Department of Justice will not tolerate drug traffickers who hide behind claims of state law compliance to mask their criminal activities. And then to add to that stance, early last year, the Obama administration issued guidelines for federal banks on the handling of proceeds from legal marijuana sales. Businesses in those states which such laws are generating all this cash revenue, but they're stuck with what to do with all that cash. That path now slightly looks a little bit more clear as banks are being provided new guidance, making it easier to work with marijuana businesses. But who knows, of course, when or if that will continue to develop. Just last month, if I can recall correctly, there was new support in the Senate for a bill that would provide marijuana businesses a place to store their money, again, in those states that have been legalized for legal sales. Now, on the other side of that coin, the Office of Drug and Alcohol Policy and Compliance, or ODAPC, the Department of Transportation, have made it very clear that the medicinal and or legal personal use of marijuana will have no bearing on the DOT-regulated testing programs. In fact, it's specifically noted in 49 CFR Part 40 of the DOT regulations that the use of Schedule I drugs, and again that's still including marijuana today, is not authorized for any reason. That being said, this also applies for the current TalentWise clients on the call today. MROs, or medical review officers, will not overturn a laboratory-confirmed positive drug screen result for marijuana solely based upon learning the donor used recreational pot within a state that has approved the legal personal use of marijuana. Again, Washington, Colorado, Oregon, Alaska, and Washington, D.C. as it stands today. As a general rule, these same guidelines are followed for non-regulated drug screening programs. Of course, unless otherwise specifically not permitted by state law and or if a company's drug-free workplace policy states otherwise. We covered how the federal and state laws conflict. I'll turn it back to Bill to review how state laws differ. They'll share some key court decisions and cover other topics of importance.
Absolutely. Thanks, Nick. Appreciate it. Excuse me. There are certain announcements that have taken place throughout the federal government that indicate or at least show that the federal government at various levels is, in fact, maybe lessening its grip on the fact that marijuana is or should be a Schedule I drug, but nonetheless, it remains so today. That conflict still exists between the federal and states' laws. But let's get back to the idea of the issue of state laws and how they compare. It's very important for the operation of your drug testing programs in your workplaces, especially for multi-state employers, to recognize that states' laws differ. And so what we want to do here just to show you is to compare California's law and how it's been interpreted with how Delaware's law reads today. Essentially, what we want to know, we all want to know, what happens if a medical marijuana patient tests positive for drug use at our workplaces through our drug testing program? What can we do? What can't we do? Well, in a Supreme Court decision in California in 2008, this company had terminated an individual, an employee who tested positive. That individual, Mr. Ross, brought a lawsuit claiming that he was wrongfully terminated because the company discriminated against him as a medical marijuana user. The Supreme Court of California ruled in favor of the employer, basically saying the medical marijuana law has nothing to do with the employer-employee relationship. The court explained medical marijuana law is a criminal defense statute. It is there for your protection to raise as an affirmative defense if you are arrested for possession of marijuana and you happen to be a authorized medical marijuana patient. Nonetheless, it has nothing to do with your workplace. Employers are free to do what they can otherwise do by state law. So at least in California, there is no solution for an employee who is a medical marijuana patient who is terminated for testing positive. That isn't the same in a number of other states. States like Arizona, Delaware, Minnesota, those laws differ significantly. And what you can see from the language that I've pulled from the Delaware statute and put on the slide here is that the medical marijuana law in Delaware does not prohibit, nothing in this chapter requires an employer to allow the ingestion of marijuana in any workplace to allow any employee to work while under the influence of marijuana to keep, except that a registered qualified patient shall not be considered to be under the influence of marijuana solely because of the presence of metabolites or components of marijuana that appear in insufficient concentrations to cause impairment. Now, what the heck does that mean? Well, essentially what we're talking about here in the Delaware statute is the results of a drug test. And in another provision of the state statute, it essentially says that there can be no discrimination against a registered qualified patient because of their positive drug test. It specifically says that in the statute. And it goes on to say, unless the patient used, possessed, or was impaired by marijuana on the premises of employment or during hours of employment. So essentially what happens here, or what we think will happen, because it's not been interpreted yet by the courts, is that a positive drug test for marijuana for a medical marijuana patient in Delaware alone is not sufficient to take disciplinary action. That can be said also for Arizona and Minnesota. So if you have operations in Arizona, Delaware, or Minnesota, you need to be real careful about how you put your company's policies together and how you take action, what actions you take if an authorized medical marijuana patient tests positive. Okay? Other states to be concerned about, we've already talked about Arizona, and we really don't have time to go into some uniquenesses about Arizona's law, because even though the Arizona medical marijuana statute says that you cannot act on the drug test alone to prove that the person's under the influence, there's another state law in Arizona that a lot of employers just aren't aware of, and it's essentially a drug testing immunity statute in Arizona. And this allows, if an employer has followed the criteria set up in that state statute and regulations, it allows the employer immunity from lawsuits for any drug test result. Clearly, in Arizona, those two state statutes are at odds with each other. We have no idea today, as we sit here, how those two will be resolved, how that conflict between those two statutes might be resolved. But there clearly is going to be an opportunity, hopefully, for the courts in Arizona to interpret those two rules, or for the legislature to resolve it themselves. Illinois is somewhat unique in that Illinois prohibits discrimination based on a person's status as a medical marijuana user. However, the statute goes on to clearly state that employers can have zero tolerance policies, and that employers can, in fact, discipline those who violate those policies. So Illinois seems to open the door, and again, there's been no interpretation in any of these four states by the courts, but Illinois seems to open the doors for employers to continue having their drug test programs and to discipline folks accordingly, whether they are medical marijuana patients or not. Minnesota, I've already mentioned the fact that a drug test alone will not demonstrate that someone is under the influence of marijuana in Minnesota, and you can only discipline someone in Minnesota if you find them to be in possession of, using, or under the influence of marijuana at the workplace or during work hours. Now, the state of New York and its statute is somewhat unique, even beyond what we've already talked about, because the statute says being a certified patient shall be deemed to be having a disability, and protection under Article 15 of the state's human rights law. That's a whole pile of stuff that we just don't have time to get into, but you should be aware that if you are operating or have operations in New York and you have folks that are medical marijuana patients, they are protected as folks with disabilities under the state's human rights law. So all that entails has got to go into the issues of accommodating that disability and so on. So be aware that that's certainly an issue you're going to have to wrestle with in New York. Okay, some key court cases. I don't have time to go into all of these court decisions. I've already told you about the Supreme Court decision in California. There have been court cases in Oregon, Washington, Montana, Minnesota, Colorado that have essentially been decided along the same lines as the California decision. And some of you are probably aware there's been a very highly publicized case out of the state of Colorado known as the Coates decision. It was Coates versus Dish Network. It was decided just recently, and essentially Mr. Coates was terminated for testing positive for marijuana, and he brought a rather unique argument under not the state's medical marijuana law, but under the state's off-duty legal use of products law. Now, you should be aware that there are somewhere in the neighborhood of 19 states that have similar laws. So you want to check into your state law and see if you have a similar law. Now, what this law essentially does, he argued, was it allows him to use medical marijuana and be protected from discrimination in his workplace because he was using a, quote, legal product under Colorado state law off-duty. Okay, well, the appellate court and the affirmed by the Supreme Court of Colorado basically confirmed, said that legal use means not only legal under state law, but legal under federal law. And as Nick has told you, under federal law, the use of, possession of marijuana continues to be a Schedule I crime. So essentially, Mr. Coates lost that case, the employer won, and that unique argument did not succeed. There have been some interesting cases that have succeeded, however, on non-discipline related items. So, for instance, in the state of Michigan, even though you might be terminated for the use of marijuana despite being a medical marijuana patient, you are still eligible for unemployment. You may be still eligible. You've got to meet all the criteria. But you may be still eligible for unemployment. In New Mexico, there have been 3 court decisions involving a work comp case where an individual was injured at work, qualified for workers' compensation, and his treating medical professionals recommended the use of marijuana as part of his treatment. Well, he sought reimbursement for the cost of purchasing that marijuana, and the insurance carriers obviously declined to reimburse him for that cost. He took him to court, and he won. And in 3 different cases now, the injured worker has succeeded in getting the courts to order the insurance providers to to reimburse them for the cost of their purchase of medical marijuana. So those are a couple of unique situations that you might want to keep an eye on. There have been and are continuing to be cases filed all the time. There are a number of cases pending around the country that we are keeping eyes on, such as a couple of cases in Rhode Island, one in New Jersey. All of these essentially arguing that you cannot discriminate against an individual with medical marijuana so long as they are qualified under state law to use. And we're waiting to see. We'll have to watch them to see what the outcome might be. We have to remember, I'm going to move on to a slightly different subject here, medical marijuana issues, personal use of marijuana issues, actually are simply one component, one piece of the big pie that makes up the compliance issue for your company's drug-free workplace program. We want to make certain that not only are you complying with the medical marijuana issues that might face you in your workplace, but all the other issues as well. We want to make certain that your company's policies are meeting the needs under those state compliance laws and are also procedurally meeting those needs as well, because there's a lot of them. Today, there are 18 states that are considered mandatory states. What does that mean? Well, that essentially means that if you wish to do drug testing in one of those 18 states, you must comply with the rules. Those mandatory rules come either from state statutes or from Supreme Court decisions in the state. We have been monitoring this stuff for a long time. I've been doing this over 30 years, and I can tell you that it's changed a lot, and medical marijuana is certainly bringing a lot more changes along with other issues like prescription drugs and synthetics. But years and years ago, when drug testing first got started, it's been in the workplaces of our country for over 40 years now, and the U.S. Supreme Court rendered its first decision on this issue, drug testing in the workplace, back in 1989, and I was privileged to be involved in that case representing a group of laboratories. What's interesting, or you may find interesting, it's interesting to me, is that when I was preparing the brief in that case, there were, at that time, only 12 state statutes, 12 states' laws that in any way impacted workplace drug testing. Today, in our database, there are well over 600 states' laws and regulations dealing directly or indirectly with a company's workplace drug testing program. Back in 1987, 88, there were only about 100 court decisions on workplace drug testing. Now, in our database, there are well over 10,000 court and agency decisions that impact what you do. Mandatory states include those highlighted here in green. If you have operations in any one of those states that are highlighted there, you must, not may, you must adhere to those states' rules related to drug testing. And I can tell you that they range anywhere from as simple, if we can use that word, to simple as California's Supreme Court decision that basically provides that random testing can only be done for safety-sensitive or security-sensitive workers. All right, that's a pretty straightforward rule, except when you start getting into the question of what is a safety-sensitive position. The Supreme Court of California has steadfastly refused to define that term. But anyway, California, that's the simple term there in terms of what the limitations are. So compare that to states like Oklahoma and Minnesota and Iowa that have incredibly detailed, almost step-by-step rules about what you as an employer can and cannot do. So if your company has operations in any one of those 18 states, please, please, please look to the state statutes, regulations, and court decisions first as you either put together your company's policy or as you begin to update your company's policy. And by the way, company policies should be updated frequently. Some issues related to compliance that I might highlight for you. These are just a few. There are so many nuances we could write a book about them. But there are 7 states that limit discipline. In 7 states, you can't fire people the first time they test positive, Minnesota being one of them. In 12 states, they limit the use or prohibit the use of random testing completely. So if your company policy, your core company policy says we're randomly testing everybody that works for us, please be careful, because in 12 states you can't do that. In 6 states in one city, I can guess at what city it might be, it's Boulder, Colorado, observed collections are prohibited. You got to make certain that your collection facilities understand that rule exists, because in that context, you as the employer are bound by what your collection facilities have done there. There are plenty of court cases that show that in that context, that collection facility is operating as your agent, and so you're obliged by all the mistakes they might make. In 19 states, there require split or retest opportunities. So if a specimen is positive, the employee or the individual testing positive has a right to have that test redone. And I'm not talking about completely redone, but a portion of the sample retested or a split specimen tested. In 14 states, hair testing is prohibited. In 7 states, it's specifically permitted. So again, if you've chosen to do hair testing, make sure you understand what states you can do it in and what states you can't do it in. Now, I will tell you that there is a case that is in the system, going through the system, but at the trial level, the court has decided, and this is Connecticut, the court recently decided that hair testing is not governed by the limitations of that state's mandatory rules. So in Connecticut, you can do hair testing. Now, it remains to be seen whether or not that case will be appealed, and if so, what the appellate courts in that state might say. But the statute in Connecticut specifically addresses the use of and limits the use of urine testing. So it would appear as if there's a change in those statistics right there. 3 states don't allow post-accident testing. So if your company policy has post-accident testing provisions across the board, you better be careful and you better find out what those states are. 16 states have specific times that limit the request for split and retest opportunities. So procedurally, you need to understand what those are. The reason you got to understand this stuff is because if you don't abide by the rules, you're going to end up paying some cash. This is just a very, very small list of the cases that have not gone in favor of the employer. And you can see the first one there, the Iowa case. In that case, where the company ended up paying $40,000, that was a case where, the employer had a person who was suffering from carpal tunnel submit to a drug test as a post-accident drug test, and the appellate court basically said, no, that doesn't qualify as an accident. That is a over time soft tissue type injury, which is not anticipated under the state statute, and therefore you're not allowed to test. So you have to be careful of what types of tests you're going to require for a post-accident in the state of Iowa. In Connecticut, once again, we've talked about this before, UPS paid $450,000 in a case where they required a post-accident drug test, and we know that in Connecticut you can't do post-accident drug tests. You can only do tests when there is reasonable suspicion. Interestingly, in that case, by the way, the supervisor involved that required the person to submit to the test was hit with a $50,000 judgment themselves for not knowing the rules. So this isn't just something the company might be hit with. You might be hit with it too if you're a supervisor for a company. You got to know the rules. As you can see, a number of years ago, ConocoPhillips misinterpreted the rules in Oklahoma, which existed at that time. It's been changed a couple of times since. But essentially, they used the wrong provider to do a collection for them. So you're responsible as the employer to make certain that all aspects of your program are following the law. In Minnesota, ING Bank lost a case where they imposed their company-wide program, their nationwide program, which basically provided if you test positive, you're fired. Well, Minnesota law is one of those, as I've said, that does not allow employers to terminate somebody the first time they test positive. You got to give them a chance for counseling. So, and I would note in that case, We don't know the amount that was paid because it was never made public. It was sealed, but I called and talked to the lawyer for the employee in that case, and I asked him to tell me the amount. He said he wouldn't, but he did say that he was awfully happy. I will tell you one thing: you never want to make a lawyer happy. Okay, so if you want to make certain that lawyers aren't happy, follow the rules. Another case out of Iowa. This is a case where an individual was intended to be hired. The supervisor said, well, go on down to the local facility there and get a drug test done. You pay for it, and we'll reimburse you. How many of you in the audience are doing that kind of thing? Well, you can't do it in Iowa because it's a pure violation of state statute. And they ended up paying out of pocket somewhere around $68,000. So make sure you know the rules. Another case out of Connecticut, I'll just talk about real quick. This is, again, a case where the company required a post-accident test. They shouldn't have required that test. Why I have it there is because what Home Depot argued was an accident in and of itself creates or establishes reasonable suspicion. And the court said, no, that's not true. So an accident alone is not reasonable suspicion, in Connecticut anyway. Okay. Drug testing. One reason we talk about work comp, and I don't know about my time here, Nick, but I'm just going to mention it real quick. We believe thoroughly that compliance can lead to opportunities for employers, and primarily that opportunity can come from defeating work comp claims. And there are a number of states that would permit you to defeat work comp claims by establishing a rebuttable presumption. There are 18 states, in fact, where if you follow the state statute and do testing according to their rules, you can raise a rebuttable presumption of intoxication and, in some cases, cause of the injury, and that shifts a heavy burden to the employee. And we've had a lot of success. We've had a lot of some of our customers have been very successful in defeating claims. I'll just highlight one real quickly here. We worked with a very large food service and hospitality company that wanted to stop the bleeding in its work comp program. And so we helped them put a pilot project in place. And they're in every state. They're in all 50 states, over 100,000 employees. And we set up a pilot project for them in 6 different states. And in just 12 months, the first 12 months of that program, they reduced claims by 20%, and they saved $6.5 million. This can work, but it only can work if you're in compliance, okay? So I'm about to turn it back over to Nick. We're getting close to our time. We're going to open it up for questions. But one thing I wanted to mention is that your company's policies need to accurately reflect the state rules in which you operate. But your company policy is just one part of the puzzle. You also then have to make certain that the procedures for actually implementing that policy are also meeting state's rules. So, in fact, your policy is just a piece of paper. It's no good if the rules implementing it aren't in compliance with state's laws as well. Now, as far as what do you do with medical marijuana in your company policies, what we're suggesting to employers today is that you simply, if you're in a state where medical marijuana has been authorized, your policy should acknowledge that. And what you simply want to say, I believe, is that the company will abide by all applicable laws. That keeps it ambiguous and simple enough for you to react to whatever's going to happen. Because so far we probably have less than 50 court decisions in the country on medical marijuana as it relates to the workplace. We're going to have a lot more. There are a lot of states where both medical marijuana and personal use laws are pending. I would say that pretty soon just about every single state in the country is going to have or have introduced a law dealing with those issues, and so you want to be prepared. All right. Well, with that, Nick, I'm going to turn it back over to you.
Wow, thanks, Bill. Tons of great information there, and clearly something for us to all keep our eyes on as inevitably will continue to evolve. Next, as Bill has mentioned, we want to leave you with some very clear suggestions and takeaways from today's discussion. And it truly does, as you've heard throughout the presentation, it boils down to your company's drug-free workplace policy. If you haven't pulled the policy documents out of the drawer and dusted them off for the last few years or ever since the day it was drafted, we can't make it any more clear there's never been a better time to do so than now. When reviewing or revising your policy, make sure your employees understand all the aspects within the policy and what you expect of them. Make sure the policy clearly specifies the prohibited behaviors, including details of the what, how, and when drug screening will take place. And don't leave any gray area when specifying the consequences that will take place when violations occur. You will need those specifics clearly outlined when the time comes for quick actions and decisions. That said, take measures based off of actions. It's very important to properly document observations and actions, especially in reasonable suspicion instances. Make it known within the policy that employees are prohibited from the use, possession, or being under the influence of marijuana while on the job or on company time, as exhibited by a positive drug test result. It's also important to ensure that your workplace policy is compliant with state laws while also considering workers' compensation and unemployment compensation laws. All very important details to include in that policy. Of course, winning question, call on an expert, whether it be our friends at TalentWise, along with their partnership with us here at Encompass Compliance, or your own internal legal counsel. It is important to get it right the first time versus learning the hard way, as companies unfortunately do, as Bill clearly covered, could be severely impactful. And now for the takeaways. Most abundantly clear is relevant for companies with federal workplace programs. If you are mandated by the federal government to drug test, you must include screening for marijuana. Even in the 4 states and 1 District of Columbia that authorize the personal use. This also applies to businesses operating under federal grants, and also in some states which require drug-free workplace policies to follow federal law. If you're mandated by state government, you also must most likely include the screening of marijuana in your program. Now, the next few bullets will address the overwhelming majority of questions that we received from attendees prior to today's presentation, which definitely does not come to me and likely Bill as well as a surprise, considering all the recent developments on this topic. Quite simply, if you're located in a state with legal marijuana laws and in some states without, you are not required to impose legal marijuana standards in states where the personal use of marijuana is still illegal. And those located in states where marijuana is illegal, the legal marijuana legislation in other states, for the most part, do not apply to you. And for everyone listening today, if you're in a state with medical marijuana laws, as Bill mentioned earlier, please review the law to ensure your compliance, as most medical marijuana laws include specific language that provide a limited amount of protection for employers. And as you've heard throughout the presentation, we cannot reiterate it enough. State laws differ and are ever evolving at an incredibly rapid pace, faster than ever before. The need to stay in tune with these changes is more important than ever. So to close, I will say it one more time. Regardless of what state you operate in, marijuana is still a Schedule I controlled substance, illegal under federal law. You may be wondering where to find all this information. I know we talked about a lot of stats, a lot of specifics by state, a ton of facts that are very, very important and relevant for our conversation. Encompass Compliance Corp is your go-to resource for questions about marijuana laws, state laws, court rulings, federal regulations, workplace policies, industry news, and much, much more. In one of our past presentations, if I can just add real quick, we ran a poll that showed only 56% of those attendees on that specific webinar admitted that they had reviewed their drug-free workplace policy more than 2 years ago. So kudos to all on the call that are up to date on their current workplace policy. And for the rest, again, I'll reiterate that with all these fast-moving changes, as Bill mentioned before, not knowing is incredibly risky. There's never been a better time to review your policy than now, and we are more than happy to help out if needed. That said, I'll take it back over to Roger.
All right. Thank you, Nick. Thank you, Bill, for your time. That was great. That was definitely thought-provoking, to say the least. It's crazy how much things change and have a tendency to change in this industry. So over time, we appreciate you guys and Encompass Compliance Corp for keeping us completely up to date with the latest and greatest with regards to occupational health legislation as well as the best practices. So that was fantastic.
We'll keep you all
I appreciate it. I know you will. Cool. So today we spent some time really digging into drug testing compliance and specifically with regards to the use and testing of marijuana. And so here at TalentWise, we're fully equipped to be your single resource for employment and random drug, alcohol, and physical readiness testing. Our occupational health services offering is part of your TalentWise Hire platform, and therein we offer a complete portfolio of efficient services to manage your entire hiring process, and we'll specifically dial into your OHS needs and ensure that it's specific to your organization. Also, just housekeeping-wise, TalentWise is a member of the Drug and Alcohol Testing Industry Association, better known as DAISHA, and we employ one of the largest OHS service networks available today in the United States. So take advantage of that if you haven't already. And finally, as most of you know that are using TalentWise, the entire TalentWise Hire platform, including any of your management of the occupational health realm, is accessible on any device with internet access, including your mobile devices and smartphones, which will help make your managing your drug screening program as efficient as possible because we know that people are moving around quite a bit. So that's something I just wanted to point out. Within our post-webinar email, you're going to find a few things, one of which being the HCRI credit, as well as a link to your very own Marijuana at Work poster, so keep an eye out for that. And also within this email, you're going to have a frequently asked questions document for you to review with a lot of great questions and answers that Bill and Nick pulled together for us, so we appreciate that. There will be more information as well as how to reach out to our team, so feel free to do that. But we will be reaching out to you directly, which I'll speak to a little bit here in a minute. So, and looking at the clock here, it looks like we do in fact have some time left to address some additional questions that were asked prior to and during our presentation today. So we're going to get to as many as we can in the time that we have available. And if you have any last-minute questions, feel free to use that chat window as I mentioned at the beginning. And if you do want a demonstration of how we manage the occupational health process as well as the entire hiring process, make sure to type in "hit me up" and we'll make sure somebody reaches out to you directly. Any questions not addressed during today's time together here at the end will be answered in follow-up communications, so keep an eye out for that. And also, we're still on Twitter, so use that hashtag #JointWebinar, and we can field your questions there as well. All right, so since we got a few minutes, let's get right into it. So the first question for you, Bill, what standard will be set by the federal government to determine if an employee is under the influence at work?
I have no idea. No, not to be flippant. I don't want to be flippant about it, but what we know right now is that there is no known means of determining when someone is under the influence of marijuana. It's not like with alcohol where you can simply take a blood test or a breath test or something that tells you that someone is under the influence. Now, there are a number of universities and individual private companies that are working on trying to develop such a thing. But I will tell you that I've researched the history of the alcohol presumptive intoxication standard for DUI purposes, and it goes way back to beginning in the 1940s, attempts to try and figure out what level we should agree upon, essentially, to basically say if you're above that level, you're considered under the influence of alcohol. And it has changed many, many times. Some of you in the audience maybe is old like me and remember that at one point it was 1.5, and now it's 0.08. So it's changed a number of times. How long it'll take or when it will come about that we can determine being under the influence of marijuana, I don't know. Now, there have been some states that have already legislated in some standards. There are 19 states that have already provided a presumption of intoxication. Now, these are for DUI purposes. This is on the criminal side of things. This is not for employment purposes. But there's 19 states that have already passed legislation establishing any trace amount of an illegal substance, not just marijuana, but an illegal substance, will be a presumption of intoxication. There are a number of states that have also passed statutes with threshold levels that will presume intoxication. Colorado, for instance, if you're above 5 nanograms, you're considered intoxicated under the influence of marijuana. In Pennsylvania, it's 1 nanogram. In Michigan, it's 15. So look to your own state's laws if you are interested to see if there is a presumptive level of intoxication or being under the influence of marijuana. Again, remembering that level may or may not have an impact on your workplace. It likely might have an impact on a workers' comp defense, but I don't know if it would in the workplace.
Great. Thanks, Bill. That's excellent. Appreciate it. So the next question that we have here is, do we see any specific testing methodologies increasing in popularity in response to the changes with marijuana in the workplace? Nick, you want to go ahead and take that one?
Yeah, thanks, Roger. So really, it goes back to applying the appropriate screening methodology to get the answers that you're seeking. Administering a hair test in my earlier example, which again provides the longest detection time window up to 90 days, would not be an optimal method of testing if you're trying to detect recent usage. Oral fluid testing, again, as I mentioned earlier, is gaining popularity in the industry because it shows frequent use. It is currently the best method to screen for more recent usage as it exists today. But still, I mean, it's 1 to 12 hours, so define what you mean by recent. There's several universities and other manufacturers that are in different stages of trying to develop early detection or earlier detection devices, but it's yet to be said what the success is there. But, urine still reigns the king and the most frequently method used for screening for marijuana. Again, I'll also add to be cautious, though, that to follow your state law, some states may restrict or otherwise have specific requirements regarding, the screening methods that you use.
Awesome. Thanks, Nick. Bill, how does that impact contract workers? What do you think about that?
Well, contract workers are an interesting issue at this moment, especially because there have been so many changes, both like with the NLRB decision in August of this year, for instance, and with a lot of different state legislatures and court decisions in terms of, okay, whose employees are they? There's been many, many changes that folks in your audience may be aware of in terms of joint employer rulings and whether or not, for instance, the subcontractor's employees will be considered employees of the general contractor if they're injured and so forth. So right now, the best suggestion I could make is that if you are a general contractor or an owner of a location and you're going to be hiring subcontractors to perform work, you want to make certain that they, not you, but that they have drug testing programs that you would approve of. In other words, there are too many different issues if you put them into your random pool, for instance. There may be tax consequences and other issues you just don't want to deal with. Just as a matter of contract, make certain that the subcontractor or the temporary agency that you're using has a drug test program that you can stand behind.
Excellent. We're up on our time. We have a ton more questions, a couple more on the screen. I think we have a ton in our chat window. So thank you, everybody, for putting those in. We are going to follow up with you. We're going to go through that and lean on Bill and Nick here to get some of these answers to you guys. So fantastic questions from everybody. So due to the overwhelming response received, we will be hosting additional presentations with updates surrounding this topic in the near future. So keep an eye out for that. Also keep an eye out for email communication with information around how TalentWise we're going to be launching a new monthly webinar series in 2016. And you'll see different topics that may be top of mind for you and your HR team. So keep your eye out for that. And finally, your dedicated resource here at TalentWise will be reaching out to you after our time together today to ensure that you don't have any specific questions and answer any questions that you have specific to your organization. So I'd implore you to take their call. We're a resource for you. We want to make sure your questions are answered. That's very big for us. So as always, feel free to share our information with anyone that will benefit from this presentation. You can see our information for contact there inc.com as well as talentwise.com. Phone number there if you want to reach out directly, but like I mentioned, we will be reaching out to you after this webinar. But I want to a big thank you to Nick and Bill for today's presentation, Marijuana at Work, Legal Marijuana Employee Drug Testing. You guys are great. Thank you so much for joining us today. That was just a fantastic presentation, and I want to wish all the rest of you a safe and happy holiday season, and we will see you at the next iteration of the webinar series here at TalentWise. Thanks so much, everybody. Have a great rest of your day. Bye-bye.